Having examined the first two arms of government, the legislature or parliament and the executive, we now turn to the third and final arm, the judiciary. The judiciary is how laws are applied and enforced, and that's done by the courts. So let's get into it. So judicial power is about interpreting the law and applying it to resolve disputes. It's exercised by the courts. Now what we have is a court for each of the jurisdictions. So that means each of the 6 states and the 2 territories have their own court hierarchy, and there's also a federal court hierarchy. Why? Well, because the Constitution says that different parts of government, remember the states have different powers compared to the federal government. So we need different court systems to interpret and resolve disputes in those particular areas. So each court is a hierarchy. That means that there's a ranking of courts, and the ranking affects what they can hear or the cases that they see. So the higher up you go, the more important the cases are, because the judges should be more experienced and more knowledgeable, etc. A court hierarchy, therefore, allows a system of appeals, so that gives us some procedural justice, some natural justice, etc. So it allows a system of appeals. It allows different forms of hearing, so more important cases are heard higher up in the court system. And we also get to see the operation of the doctrine of precedent. It allows for the doctrine of precedent. We'll do that next week. We talk about the doctrine of precedent. I want to really stress here, it sounds like we're going into a lot of detail about this court hierarchy, etc., and we are. Will you ever need it? Probably not. You'd get a lawyer. But you need to understand this and have this basic knowledge in order to be able to explain and demonstrate you understand the doctrine of precedent. And that is important to a conceptual understanding of Australia's legal system. So we do have a lot of detail. A lot of that is so that then you can show you understand how our legal system works, rather than just memorising it for memorising its sake. And indeed, that's why we allow you to take notes into the exam, etc. So you don't need to memorise it, but you do need to understand how it conceptually works. Okay, so courts have an original jurisdiction and an appellate jurisdiction. What does that mean? Well, the original jurisdiction is when it hears and decides an issue for the first time. It's also called the court of first instance. Then courts often have an appellate jurisdiction. That's when it gets an appeal from a lower court within the hierarchy. Okay, so that means it's already been decided and someone doesn't agree with the decision, so they have an appeal. And courts often have this original and an appellate jurisdiction. Most courts exercise both. Most courts also have both a criminal and a civil jurisdiction. We won't go into too much detail about that. We just recognise that we do have those 2 jurisdictions. Recognising the 2 jurisdictions allows us to differentiate some terms so we can be sure that we understand what's going on. Now the parties, the people involved in the court case, in a civil dispute, which is mostly what we're going to be dealing with in business law, we're going to have a plaintiff, the person who brings the case, and the defendant, the person who defends the case. In a criminal court, it's society who is actually bringing the action, right? So the Crown is one of the parties. They bring the action and a person defends that action. The burden of proof. Who has to bring the proof? Who has to prove their case? It's the person trying to make the case who's making the argument. So in a civil case, that's the plaintiff. The person who brings the complaint has the burden to bring forward the proof of their case. In a criminal case, it's always on the Crown, right? The defendant doesn't have to prove. They don't have the burden to prove that they're innocent. The Crown has the burden to prove that they're guilty. Okay, what is the standard of proof? So you have to bring proof, but how much proof do you need? That's the standard of proof. How much proof do you need? Well, in a civil case, it's the balance of probability. So it's kind of like more likely than not. Okay, for lots of very good reasons for a criminal case, because you're going to be punished, etc., because we don't want to lock up people who are innocent. All kinds of problems can happen with a legal system if you're locking up innocent people. People lose confidence in the system. So because of that, we have a higher standard of proof for criminal issues. It's beyond a reasonable doubt, right? So it's really, you can't think, there's no good reason you could think they were innocent. Okay, that's very different to more likely than not. That standard of proof is quite different. Very occasionally you might have a jury in a civil issue. You most likely think of juries being involved in criminal issues. They're for major offences, indictable offences. We do note that you can have trial-only juries in Queensland. We'll come to why. Essentially it has to do with getting a fair trial. Sometimes juries might not lead to a fair trial, and under certain conditions you can have a judge-only trial for indictable offences. What's the result from a civil? Well, either the case is proved or not proved. Criminally, you're either guilty or not guilty. Notice, not guilty does not mean that you're innocent. It just means you couldn't show someone was guilty, okay, which is different. Okay. The outcome from a civil case is a remedy, okay, to get people back to the position that they are in. The outcome from a criminal trial is punishment. So there's some important terminology and real differences in how court cases proceed civilly and criminally. So here we have our first court hierarchy. This is the federal court hierarchy. What you'll see is there are essentially three elements to the court hierarchy at a federal level: the federal court, the family court, and the high court. Let's have a look at them. The high court is actually as the name says, it's the highest court in Australia, the ultimate court. Now, it does have an original jurisdiction. You can go to the high court for constitutional issues. So it hears at first instance constitutional issues. However, its main role is as an appellate court. So any court in Australia, any court hierarchy in Australia, a decision from any court hierarchy can be appealed to the High Court of Australia. This is how we get a uniform approach to law in the Commonwealth. Because at the end of the day, you have one court who can interpret laws coming from any state, any jurisdiction, federally, etc. Okay, so this is the unifying element. Now, it's hard, you just can't automatically get an appeal to the High Court. What you have to do is you have to seek leave. They call it seeking leave to appeal. So you ask them, can I appeal to you? And the High Court will only hear the most important cases, ones with very important legal policy outcomes, implications. They're the kinds of things. So it's not simply that you can always appeal there. You have to seek leave. Okay, so that's the High Court. It has a limited original jurisdiction about constitutional issues. However, it is the main, it's the ultimate court of appeal that unifies all the different hierarchies in Australia. Now, we also have two other court hierarchies. In order to get a consistency of family law in Australia, and because it's such a specialised area of law involving families and the health and well-being of young people, there's a specialised court system for family court, for divorces, etc., and those kind of things, custody battles. So there's an original jurisdiction and an appellate jurisdiction, the full court of the family court. So at first instance, your case would be heard here in the original jurisdiction. If you weren't happy with the decision, you could appeal to the full court. If you still weren't happy, then you could seek leave from the High Court to hear it. And if there was an important legal issue, they might hear it. We have the same hierarchy and structure in the federal court, an original jurisdiction and an appellate jurisdiction in the Federal Court of Australia. Now, the federal court only hears limited areas, right? It's the area where the federal government has the power under the Constitution to make laws. So areas like intellectual property, we'll come to that in a moment. Other areas like criminal law and contract law will be heard in a state system. Okay, so we'll get to that in a minute. But this is the structure of the court hierarchy for the federal government. So as we can see, the High Court is the highest court in the judicial system, and it's at the top of both the federal and the state court hierarchies. It's the final court of appeal from any decision in Australia. Appeals to the High Court require special leave. You've got to establish that the dispute is so important that the High Court should hear it. They will do that if they think that the case will develop the law and reform the law. From a historical perspective, the High Court wasn't always the High Court. You used to be able to appeal over to Great Britain, to something called the Privy Council, which sits in London. However, that ended quite some time ago in 1986. One of the reasons that we mention it is that you often see decisions in the Australian system that refer back to the British system. The reason is because of this link, right, that goes back to not that long ago, 30 years ago or so, to this appeal to the Privy Council, which unified our system with the British system. So we just like to remember that historically. But remember, it isn't the case now. The highest court in Australia is the High Court. The High Court has 7 members, 6 justices and a Chief Justice. In an original jurisdiction, the High Court hears cases like constitutional issues, and generally there's one. In the appellate jurisdiction, the High Court can hear appeals from Supreme Courts and the full court of the Federal and Family Court. You need special leave, as we've mentioned. Okay, the Federal Court. So what is the Federal Court? In original jurisdiction, where you have a single judge sitting, they will hear things like consumer protection, competition regulation, intellectual property, federal tax, immigration. These are the powers, right, under the Constitution. That's why we need to understand that Constitution, right? Because that tells us what the court will hear. As an appellate jurisdiction, it normally sits as a full court of 3 judges and hears appeals on decisions from the first instance, the original jurisdiction. The family court in the original jurisdiction, again, is a single judge, hears matters about divorce, property settlements, custody and maintenance of children. The full court sits and hears appeals from a single judge.